Welcome, everybody. Just wanted to welcome you all. I am Judge Mario Choi. I'm an administrative law judge with the Office of Administrative Hearings in Oakland, California. And I also teach this class, the Prozan Motions Competition Intensive. Just wanted to welcome you all this evening to this competition. We have two great students here who did really well in both the orals as well as with the briefing. And I want to congratulate all of them, including my other students, for participating in this first ever Prozan competition, my so-called guinea pigs. And I appreciate all of you for joining us this evening. And without further ado, are we ready to begin? Let us begin.
All rise. The court is now in session. The Honorable Judge Prozan presiding.
You may be seated. Should say good evening, everyone. Good evening, everyone. Good evening, counsel. We are here on Defendant Marine Data's demur to the complaint in Ocean View Analytics versus Marine Data Systems. I've reviewed the papers, including the complaint, the demur, and the opposition. Counsel, would you please state your appearances for the record?
Yes, Your Honor. Sean Silverman.
Stand when you make your appearance.
Sean Silverman for the Movants, Marine Data Systems.
Thank you.
Sarah Wu, counsel for the plaintiff, Ocean View Analytics.
You may be seated. I'd like to focus the argument on two issues. Number one, whether the complaint adequately pleads a trade secret under CUTSA, and two, whether the allegations of misappropriation are sufficient at this pleading stage. Defendant, your motion. You may proceed.
Good evening, Your Honor. This case is about an ordinary business dispute escalating because of the hasty filing of a deficient complaint that puts legal and technical labels before facts. And we ask that you sustain our demur to that complaint for the reason that the complaint fails to allege sufficient facts establishing trade secret misappropriation. So I want to briefly touch on the standard of review for this motion. A complaint must allege ultimate facts sufficient to meet each element in every cause of action. And when reviewing whether this complaint is sufficient, while the facts alleged are viewed in the light most favorable, that does not extend to contentions, deductions, or conclusions of fact or law.
Counsel, I'm going to stop you right there. I did say that I wanted to focus on two specific issues. Does the complaint adequately plead a trade secret?
No, Your Honor.
Why not?
So under section 2019.210 of the California Civil Code, a plaintiff in a trade secrets case must provide a description of the subject matter of the trade secret with sufficient particularity in order to distinguish it from general knowledge within the industry. And that was not done here. This complaint doesn't meet that reasonable particularity requirement, but in fact, there's actually a higher standard as well. The Court of Appeals in Advanced Modular Sputtering recognized that in cases involving advances in highly technical fields, such as this one, an even more exacting level of particularity is required. So I want to get to why the alleged trade secrets in this complaint don't meet that level of particularity. So instead of being particular, all of the alleged trade secrets within the complaint refer to general categories of information in technical terms without substance. So on paragraph 16 of the complaint, the plaintiff alleges that its trade secrets, at minimum,
Hold on, let me pull up the complaint. You said page,
page 2, paragraph 16.
thank you. Go ahead.
So those trade secrets, at minimum, include signal processing pipelines, an adaptive beamforming approach, multipath bathymetric refinement systems, and parameter tables and lookup schedules.
And were those parameter tables or confidential parameter tables?
Confidential parameter tables, Your Honor.
That feels like a trade secret to me.
Well, Your Honor, in fact, the court, the Ninth Circuit in IntelliClear v. ETC Global held that parameter tables can't be considered a trade secret unless they are specific parameter tables or containing unique columns within those parameter tables. It has to include not only this general concept of a parameter table, but also the data that is the trade secret within them. And here, just listing the idea of a parameter table is insufficient to meet that exacting level of particularity. Regarding a signal processing pipeline, it's the software equivalent of an assembly line. It basically allows different parts of a program to run concurrently as opposed to sequentially. And it's something that's been used in all sorts of programs, not just the seafloor scanning technology at issue here. An adaptive beamforming approach, well, that describes focusing an array of antennae on a single source. And journals, there are about 100 journal publications each year concerning adaptive beamforming approaches and their techniques. It's something that's common not only within this industry, but others as well. It's been around since the 1960s.
There was a different case, pardon my interruption, there was a different case, Brescia, where the court emphasized that the trade secrets need only be described with reasonable particularity. Every term you have just stated is extremely technical, which seems to me to be reasonably particular.
So, Your Honor, the plaintiffs in Brescia actually distinguished their case from advanced modular, and that it wasn't a case about these highly technical fields, but one about the ingredients in a pudding. Whereas here, we're talking about seafloor scanning technology, and thus the terms are going to be more technical, but they're still these general concepts. In fact, in Brescia, the plaintiff was required to file, I believe, 350 documents, additional documents, to meet that trade secret sufficiency for identification. And here, all we have is this complaint with these very general terms. It doesn't meet that identification requirement. And that identification requirement is important because it deters meritless litigation and fishing expeditions. It frames the scope of discovery, and it enables an adequate defense. Without this, we'd have to be kind of combing our software, anything that resembles parameter tables, in order to determine how to merit a defense against this allegation. At the moment, that's impossible to do given the generality of these terms. Let's imagine this as two sandwich makers, kind of going to the recipe that I talked about in Brescia. Imagine a trade secrets claim that covers bread, cheese, and tomatoes. Those are much too general for any defendant to actually reasonably defend against, because sandwich bakers typically use all of those ingredients. And that's the same in the seafloor scanning technology industry. It's something that every industry, every competitor kind of within this industry uses. And therefore, just alleging these general concepts as trade secrets which violates that particularity necessary under Section 2019, it means that defendants can't adequately defend themselves.
I think I've heard enough on that issue. The second issue that I wanted to hear more on is the allegations of misappropriation being sufficient at this pleading stage. What do you have to say?
Of course, Your Honor. So regarding the allegations of misappropriation, the complaint asserts several legal conclusions instead of facts supporting misappropriation. So some of those include an allegation that their trade secrets were on information and belief that Marine Data acquired, used, or disclosed those trade secrets. But it isn't supported by sufficient facts in order to meet that element of trade secret misappropriation.
Let me ask this question. Do you think there's a difference between access to information and acquisition of the technology?
So, Your Honor,
Because it's shown that there was access for sure, but similar to a different case, there was no downloading, let's say, downloading of files.
Your Honor, regarding that access, the plaintiff actually hasn't in their complaint described which programs and which trade secrets each employee had access to. That's something that they could have done, but they just described the employees by their titles as opposed to which trade secrets they could have had access to. Or, in another instance, what measures were protecting those trade secrets and whether they applied to the employees at issue. So regarding that acquisition, we don't believe that's something that the plaintiffs have shown here. We don't know how the employees took any trade secrets to Marine Data, and we don't have anything beyond inferences and these kind of on information and belief allegations, which are conclusory and not facts, that Marine Data actually misappropriated any of these trade secrets. Essentially, OceanView asked this court to rely on the discredited theory of inevitable disclosure. And the only facts that they allege are that the employees left OceanView, went to Marine Data, and then started working on similar programs. But the court in White v. Schlage Law Co. Held that these theories of misappropriation are insufficient to actually allege a claim of misappropriation. You need more than just employee movement. It's not inevitable under California law and precedent that they will then disclose that information. And that's basically all that the plaintiff alleges here.
Final question. If I were to overrule the demurrer but to require a prompt 2019.210 disclosure, does that address your concern?
No, it does not, Your Honor.
Why not?
We would need you to sustain this demurrer because enabling a 2019 disclosure, we wouldn't know the boundaries in which you would need that 2019 designation without the specific identification of the trade secrets at issue here. And the 2019 designation and this demurrer alleging that the plaintiffs have not pleaded their requirements as to the specificity of those trade secrets goes to the same general policy concerns, enabling the boundaries of discovery to be ascertained, preventing meritless litigation. In fact, in Silverco data systems, the court said that it's not relevant whether the plaintiffs would then file a 2019 designation. What matters now is the insufficiency of the complaint at issue. And because the complaint doesn't allege their trade secrets with specificity, this court should sustain the demurrer. If you have any further questions, I'm happy to answer them. But otherwise, I'm happy to let you go and ask my opposing counsel about this issue.
Thank you, Mr. Silverman. Ms. Wu? Please proceed.
Thank you, Your Honor. Defendants demur today improperly asked the court to require evidentiary detail and technical specificity that is not required at the pleading stage. Such standard would force OceanView to disclose the very trade secret we're here to protect. The defense counsel starting by citing a wrong pleading standard. The defense argued that the proper standard is the reasonable particularity in Section 2019. That is not correct. In both diodes at Section 2019, Both the case and the statute use the term reasonable particularity, but their meanings are significantly different. In diodes, the standard is to draw an ascertainable boundary in which the trade secret lies. That is the pleading standard. Section 2019 is meant to help the court to draw the proper scope in which a discovery can commence. And in Briscia, the court has made it very clear that Section 2019 does not govern the pleading stage, only discovery. In Coase hematology, the court also found that the mere absence of a Section 2019 statement is not a basis to sustain a demur.
Let me ask you this question on the specificity. At what point does a categorical description become too vague? Why is what you've alleged enough?
Yes, Your Honor. So the most important point the complaint has alleged is to appeal to the combination theory under Altavian. First of all, we did also claim that the 4 categories are each proprietary. Defense counsel today disagree, but Marine Data, his own client, is actually on our side. If you look at paragraph 12 of the complaint, Marine Data promoted exact identical technologies as propriety. However, that's not the most important point. The most important point is, under Altavian, the court has found that the CUTSA does not only protect the trees, but also the forest. The trees...
What does that mean?
Yes, absolutely, Your Honor. The trees are referring to technical components, whereas the forest is referring to a successful combination of those components. The defense counsel is also inaccurate in claiming that a pipeline, a signal processing pipeline, is like an assembly line. Therefore, it is not proprietary. Henry Ford's assembly line was famous for how effective it was, and thus making it different from other assembly lines of his time. But coming back to the combination theory, the court has never said under Altavian that the complaint has to include the magic word combination. Rather, the definition of combination is a successful, valuable, and effective integration. And Your Honor, in front of you in the complaint, paragraph 5, the term integration is exactly there. We also satisfy the information and belief pleading standard under GOLM. And here, we're not just alleging that we have a product. We also have the underlying information forming those products. And Your Honor, if at this point you're still a little bit skeptical regarding whether these 4 technical categories can each be proprietary, in advanced modular, which is another case the defense counsel rely on, in advanced modular, the court has made it very clear that even if individual elements are already in the public domain, even if all of them are, the integration of those elements into a functioning system is still protectable. The defense counsel, sorry.
Oh, I'd like to talk a little bit about misappropriation.
Yes.
Your theory relies heavily on timing and employee movement. Do you have any non-inferential facts of acquisition of use?
Well, Your Honor, we have 4 factual predicates in total alleged in the complaint from paragraph 9 to paragraph 10. Your Honor, you have already mentioned access and timing, and the other 2 are the 2 accounts of similarities. The 2 accounts of similarities are first parallel techniques, namely the adaptive beamforming approaches and bathymetric refinement system, as well as a similarity in performance benchmark, which is a 35% increase in resolution. And previously in Sergeant Fletcher, the court has allowed the finding of an inference about misappropriation theory based on access plus similarity alone. In another case, Jaxo versus E-Trade, the court also allowed timeline plus access plus similarity to form an inference chain. And previously in medicine tech, the court has made it very clear that circumstantial evidence is sufficient and particularly appropriate for trade secret case at this stage, because the court recognized that at this stage, a few plaintiffs in a trade secret case would have anything but circumstantial evidence. So taking together, the 4 predicates has sufficiently alleged a misappropriation theory that would allow the court to draw an inference. And as to the pleading as to the and/or language in the complaint, the defense counsel addressed. Here in California courts, pleading in the alternative is permitted. And again, as the plaintiff in a trade secret case, we're merely facing the very restraint that every plaintiff would face in this case, which is that we do not have internal access to Marine Data's internal system, nor should we at this stage. That is why a Section 2019 statement under a protective order is so important. But at this stage, we're simply following the practice of pleading in the alternative to satisfy the standard.
And I'm sorry if you had already said this, but what was the case that you relied on pleading in the alternative?
I'm sorry, Your Honor, for the pleading in the alternative, I'm only relying on the general rule and common law doctrine of it. I did not have a case to support it.
In the future, you might want to have a statute on hand.
Yes, Your Honor.
Keep going.
Yes, Your Honor. So if you allow me, I would like to go back to the subject matter for a moment. The defense counsel, or if there's any other
go
issue
ahead,
you would like
go
to.
ahead.
Thank you, Your Honor. The defense counsel also alleged that in advanced modular, there is a heightened particularity standard that we have to follow. However, in Briscia, the court has commented extensively on advanced modular. And in Briscia, the court has said that even if advanced modular has contemplated this heightened standard, the purpose is still to separate those that are generally known from those that are protectable. So here, advanced modular is not creating a completely different rule from diodes, but rather is to create something in a very particular situation. And again, Your Honor, even if advanced modular heightened standard particularity apply here, we're not pleading on an incremental value on a one particular technical categories. Rather, we're talking about the implementation and the information that took to put everything together and make it successful. And that 35% increase in detail resolution is no doubt proving that it is a successful combination. To make it simpler, the defense counsel used a sandwich analogy. I also have analogy on food. My grandparents have a spring roll recipe that is very good. I can also make the claim that, as well as the paragraph 6 of the complaint has made, that at minimum, the recipe includes wrappings, eggs, and carrots. While these ingredients are widely available in the market and the public has general access to them, the particular cooking process, the amounts in each spring roll, and assembly process are uniquely my grandparents'. And that is the exact type of definition we're asking the court to protect under Altavian. And that is also the factual predicates that differentiate us from Silvaco. In Silvaco, what the plaintiff has was a finished product, an executable code. And the plaintiff does not have any knowledge about what actually composed the code, what is the underlying procedure about it. So here, we do have the factual allegations to support our claim. In terms of the existence of a trade secret, there are also two additional elements. CUTSA defines a trade secret as an information that derives independent economic value from not being generally known and is subject to measures that are reasonable in circumstances to protect its secrecy. I have already addressed the subject matter, which is the combination theory. Now, I would like to address the independent economic value as well as a reasonable effort to protect the secrecy. For the independent economic value, the rule, even under Gomes or Young, the cases the defense had relied on, is not that the complaint can never include any statutory language or conclusion, but the rule is that these conclusions must be supported by factual allegations. And here we do have these factual allegations. Your Honor, in paragraph 10 of the complaint, Ocean Map has an industry-leading resolution of 35% increase in detail. DeepScan, our product, closely tracked that performance benchmark. That is exactly the type of independent economic value the Moorlift Court has talked about.
I'll ask again,
Yes.
since you returned to it. Do you have any comparable factual allegations here besides circumstantial?
I'm sorry, Your Honor, would you please clarify in which?
Do you have any comparable, concrete, factual allegations here that you would like to, besides the combination, besides the circumstantial evidence, anything else that you would like to share with the court?
No, Your Honor. And Your Honor, I would like to say one more thing, is that at this stage, the plaintiff does not have to factually prove anything. The complaint ought to be taken as true. What was alleged in the complaint ought to be taken as the true. And here we believe that all the factual allegation we have alleged, taken as true, has already successfully stated the cause of action.
Well, that is true. Is there anything else you'd like to add?
No, Your Honor, if you have no more question about the independent economic value and the reasonable measure, I have nothing else to add besides those two elements.
And so are you submitting?
May I please address the two elements?
Sure.
Yes, Your Honor. So as I have mentioned, in Moorlift Court, the court has found that independent economic value is established by showing that the holder has a competitive advantage from those one who do not know or how to use it by possessing that information. That 35% increase in detail resolution for both Ocean Map and DeepScan, especially in DeepScan, would no doubt give OceanView a competitive advantage over the conventional system in the market, therefore translating into independent economic value. Another place is in paragraph 12 of the complaint, where marine data themselves market their trade secret, namely the adaptive beamforming approaches and bathymetric refinement system, as proprietary. And in Altavian, the court has established that circumstantial evidence such as the behavior of the competitor can help us to know whether there is such value in the information. And a competitor wouldn't market something as proprietary unless the market is willing to reward it for its exclusivity. And now moving on to the reasonable measure to safeguard our secrecy. The standard here is reasonable, not perfection. And the defense counsel also in passing addressed this issue, and he claimed that we have not been specific enough. But again, we're at the pleading stage, and everything we're putting into is putting into a complaint, which is a public document. If we review too much of a company internal operation or our trade secret, that would defeat the very protection we're seeking to protect. Here, Your Honor, in paragraph 8, we have alleged many measurements. First is confidentiality agreement. Second is access controls. Then there's code repositories and confidential markings along with technical controls. Taking together, the standard is seen again in Sergeant Fletcher, which is that the measures were reasonable given the nature of information and the particular threat this type of information may face. And in Fire Spectacular, the court has also found that employers need not turn its companies into an impenetrable fortress for the measures to be reasonable. And the defense counsel also concede that we have alleged some reasonable effort here, or at least some effort. So at this moment, the question is not whether some factual allegation regarding the measurement exists, but rather regarding to which level these measurements are actually reasonable. And on that question, that becomes a factual question that the court would have to resolve after a Section 2019 statement and after discovery. And here we believe that we are more than willing to submit a Section 2019.210 statement under a protective order to safeguard both companies' secrecy. Thank you.
And if I allow this to proceed, how quickly can you provide that disclosure?
Your Honor, we would like for the court to order a protective order first, and within 14 days, we would like to submit a Section 2019 statement.
Thank you. Turning to my other colleagues to see if they have questions. Okay, at this time, I believe myself and my honorable colleagues will be. Oh, I'm sorry. Defendant, your motion, I apologize. You have closing statement.
Of course, Your Honor. So I wanted to touch on 3 points regarding what my opposing counsel just talked about. So regarding that 2019 standard, in both adaptive sputtering and Brescia, the court combined that standard with the necessities for a complaint just because they serve the same purpose. It's ascertaining the boundaries in which the trade secrets lie. And that's why the court in advanced modular required that additional expert testimony to describe a combination of listed features. That's something that the plaintiff doesn't have here. They don't have any sort of testimony alleging how their features have been combined to a singular product. And that's something that advanced modular required in order to deny the demur. Regarding Brescia, I mentioned that 250 pages of additional documentation, and that was just regarding a pudding recipe. Here, plaintiffs haven't provided anything nearly as much. And so the 2019 designation wouldn't be sufficient in order to address the issues with this complaint and the demur right now. Additionally, in Altavian, which opposing counsel brought up, the combination there of a barcode scanner was unique. And the plaintiffs here haven't alleged anything unique about their product. It was because of that uniqueness that it could be considered a trade secret and not just a general category or process.
Counsel, what is your reaction to the combination theory then?
So, Your Honor, the combination theory isn't relevant here because the plaintiff hasn't alleged how, in combination, its different processes make a unique product. They just listed the general categories which might be combined. In fact, in Silvercode data, a plaintiff listed subcategories regarding a proprietary method of carrying out a function that was included, that was something that was also included in competing programs. That's basically exactly what's happened here. But the court noted...
But isn't the combination theory the mixing of those ingredients together to get to a certain product?
Yes, Your Honor, but
and you've raised pudding, you've raised sandwiches, she's raised her grandparents' recipe. I mean, isn't that what we're getting at?
In Silvercode, the court said that it's not just the combination that's important, it's the information that really drives the program. And you can't point to what efficiency benchmarks or measures that combination could produce. It's the information that's contained within that program. It's the ability to differentiate each of those aspects that was combined into something that can be determined to not be in this general category information that's known to competitors and known within the industry. That's the whole point of a 2019 designation, is that it allows the defendants to understand that these trade secrets aren't just generic categories, that they're something unique. And that's not what the plaintiff has alleged here. In order to defend ourselves against such claims, we would be worried that the plaintiffs could expand beyond these categories. Note the at minimum statement on paragraph 6 of the complaint. The plaintiffs potentially could expand beyond these mere categories and attempt to claim trade secrecy over anything they find in Marine Data's documents through discovery. And that's just not permissible. In Perlon Therapeutics, we had a similar case where the plaintiff described their combination, their invention, under general terms and general processes, such as multimerization, peptides, glycosamine. These are kind of general technical terms within that industry. And the demur was sustained because it wasn't apparent that those categories actually contained specific data that the 2019 designation and the demur at this stage requires. Regarding the protection measures in misappropriation, that the plaintiff has alleged that they had several protection measures, but what they haven't alleged is that those protection measures actually applied to the employees at issue, which in the court in White v. Schlage Law Co. held to be dispositive, where it couldn't determine whether the employees at issue who had left the company actually had been subject to those security measures. And that's why they're insufficient.
Anything else?
No, Your Honor. For those points, we ask that you sustain the demur at this moment.
Go ahead, Ms. Wu.
Thank you, Your Honor. A few points. First of all, I would like to start with Perlin. Again, the defense counsel maintained that Section 2019 standard is a pleading standard. That is not accurate. Again, in Briscia, the court has made it very clear that Section 2019 only governs discovery, not pleading standard. In Coast Hematology, the court again said that the mere absence of a Section 2019 statement would not render the complaint to be uncertain or be the sole basis of sustaining a demur. So it wouldn't make sense if the two standards are actually the same. Diodes precedes CUTSA, and Diodes, the reasonable particularity, still governs pleading, whereas, Diodes precedes Section 2019. Whereas in Section 2019, again, as the Brescia Court has made it very clear, it is about to draw the boundary or the scope of proper discovery. However, under Diodes, the reasonable particularity is referring to a boundary, an ascertainable boundary in which the trade secret lies. And that brings me to the at minimum language in complaint paragraph 6. That at minimum language does not go beyond the boundary that we have already drawn, which is everything that ties to DeepScan's hardware. We're not trying to allege anything beyond that hardware. So that at minimum language does not make our complaint uncertain or legally insufficient. The defense counsel also compare our case to Perlin. But again, first of all, Perlin is a case assessing Section 2019 statement. It is not a pleading standard case. It did in some level give some context regarding a pleading standard, but even if it gives us some context to refer to, the facts are clearly different. Here, we're alleging that our trade secret is a product. It is a product that has already been proven successful, namely that 35% increase in detail resolution. However, in Perlin, the product is not really a product. It is a concept. It's an idea. And also, in their Section 2019 statement, they have included almost 200 pages of attachment, which the court has found to be excessive. And here we have not reached that stage yet, but even we're there. Here, our product is significantly different because it's a tangible thing. It is not an idea or a concept where the defense counsel do not know where it begins or where it ends. Additionally, on misappropriation theory, the defense counsel alleged that we have relied on White. We did not. We did not solely rely on the doctrine of inevitable disclosure. The doctrine of inevitable disclosure was relying solely on the fact that the employees had previous access to the trade secret and were later employed by other competitors. But we have 3 additional factual predicates from paragraph 9 to paragraph 5 to the complaint to form a misappropriation theory. And again, courts in Madsen Tech, Sergeant Fletcher, as well as Ajexo have repeatedly allowed this sort of approach to rely on circumstantial evidence. And in terms of the reasonable measure to safeguard our secrecy, the complaint has made it clear that these measures were used during the development of DeepScan trade secrets. Whether these elements are actually applying to the specific employees, well, by the nature of them working in and under DeepScan, they have already been subject to role-based access control, for example. And whether they personally have signed the NDA or not, that does not give them the right to disclose a trade secret, and that also doesn't matter. And those secret and those details, those additional factual detail regarding my client's company's internal operation are details that were revealed in the Section 2019 statement, not at a demur stage. Your Honor, again, I ask you to overrule this demur because we do not want to defeat the very protection that we're trying to enforce today. Thank you.
Thank you, counsel. I believe at this stage, the three of us will be going into chambers and discussing your arguments.
Okay, folks, while the judges are deliberating, I just wanted to present 2 awards this evening. So in addition to presenting whoever the judges will present as best argument and finalist, I have the privilege of presenting 2 memo awards. One for best memo in support of the motion for demur, for demur, and one in opposition to the demur. It was blindly graded, so I didn't know who wrote what, and in order to make sure that this is as impartial as possible, especially since the fact that I don't know any of these students. These are all of the students that were in my class the first time I met them. So it was as impartial as I could be. So first, I wanted to give out the memo, the best memo in support of demur. And the individual who has earned this award is Austin Prather. Okay, and then for best opposition to the demur, and I'm hopefully not going to mispronounce names, but forgive me if I do. Best memo in opposition is Aria Rosian. Excellent. I try. Thank you. Congratulations. Thank you. For those of you who are students and are second years or incoming 3Ls, we plan to do this again next year. So if you're interested, please sign up. And we'll now wait until the judges have come back to give feedback and to let the competitors know who has earned best argument.
So the three of us convened. We were all exceptionally impressed with both of you. I will start with Mr. Silverman, since you were the first to present and took most of my heat. You respond really well on your feet. You were very prepared. You tied it to the trick to practicing law well is to, one, always make it easy on the judge. Always make it easy to rule in your favor, and answer the question that was asked. What I liked there was something that I asked you, I was asking you was, if I did the 2019 disclosure, does that address it? You said, no, it does not. I want my demur and I want it today. That may not be the best practice in real life when you are dealing with a client who's paying the bills. But I liked how you advocated for it and you stood your ground. So that is my off-the-cuff feedback. Ms. Wu, the way that you wove the law into the facts, you took it to the next level. Brilliant. You should be considering a career in IP if you're not already. your combination theory, the way that you were putting the pieces together, the way that you wove in case law into, I needled you on that pleading standard only because I had a judge that did that to me and made my life hell for 48 hours. And it was a good memory, so thank you for letting me relive that in my head. But you, seriously, extremely, extremely, extremely impressive. I'm going to turn to the real judges to give some more feedback before the ruling is given.
Yeah, I want to preface what I'm going to say by saying that when I read this fact pattern and I read the complaints and things, I thought the defendant really had a tough time with this because of what the facts are and because of, what the law is. So, in real practice, that sometimes happens, and you have to make your argument and give no quarter, and I thought you did that effectively. You talked about the cases with fluency. You made a reference to what you were arguing in the complaint. That was good. In answering the questions, sometimes I felt you could have been a little bit more direct in answering the judge's questions, but I think that's also a function of the fact pattern you have here. It's just a really tough one. Great knowledge of the case law, good oral argument skills. Let's see, there was another comment here. Just one thing, and I say this to both parties and to all of you, be really careful when you're arguing a demur that you don't start talking about what the standard for a demur is, because if you've got a judge that's been on the bench more than a couple of years, they've heard that so many times they don't want to hear it again. Now, it's good that you know that, and it's good that you bring it in, because if the judge starts wandering off and you feel the judge, then it's okay to remind him, but don't start off on that, because it just, the judge is kind of like, oh, yeah, get to the meat. But I thought you did an excellent job in what you did.
So I just wanted to say that I thought that both of your arguments were one of the best arguments I've ever heard in court. So I think you are comparable to any barred attorney that I've ever heard in California. So I think, I thought you also made it a subject area that I don't find particularly interesting, very interesting. And so in that sense, I thought both of you were extremely effective and persuasive, and clearly knew your facts backwards and forwards. And of course, as zealous advocates for your position, obviously argued to your, the best facts for your argument. Both of you did that, and that's what you're supposed to do. So I thought I was extremely impressed, and I think, one thing you should walk away from this experience is to know that you are certainly ready for practice, and you would be comparable to any attorney that would appear in court. Actually, probably much better than the ones I've seen. So I'll say that. So I'll give more then I'll go person by person. So as Judge Grillo has said, it's not necessarily when you're arguing a demur, you're arguing for a demur. That's not always the best position to be in, because the law isn't exactly very favorable to your position. But I would say it's, I thought you made a very, very strong argument that they weren't specific enough. And I thought that you were able to kind of take the complaint and say, on its face, you might think these things are so incredibly complicated and secret, but they're actually less complicated and less secret than their complaint would suggest. And you were able to argue and show, I think, that while the other side would argue that you were able to, I think, persuasively suggest that they were asking the court to kind of infer that they had access, but that had not necessarily been shown, and that they had acquired these trade secrets. So I thought you took a position, you're obviously in you're taking a side that is not always easy, but I thought you gave it the best possible argument it could have. So I wanted you to know that. And then for the plaintiff, I think that you gave very good analogies. You very passionately argued why it should be denied or overruled. And I thought your knowledge of the facts, right, the way you were able to cite to cases and differentiate them with particularity and with precision is amazing, and will suit you very well in practice, because that level of attention to detail is what will often set you apart and make you a reliable person for the judge to rely on, right? So they say, wow, you know these facts so detailed, you'll become that kind of trusted voice in the courtroom. So I think that's my feedback for you. And then, I'm sorry, I apologize. Okay, well then I'll let you. I'll give you the last word. But I would also say one thing to Mr. Silverman did it a little bit, which is kind of started off with kind of grounding us in why we're here, which was your position was we're here, this is a hasty complaint to basically fight competition. And I find when people ground the argument about what's at stake, I find that to be quite powerful. So I think you talking, for example, about this is hasty, this is basically to fight competition in the marketplace. This is to try to, beat another company, up and coming company. I think that's something, you're talking to a judge, not to a jury, so you can be measured in how you say it, but I think letting the judge know what's at stake for your client is important. And then I think, of course, for the plaintiff, your point is, right, we've worked very hard to have a competitive edge in the market, and somebody should not be allowed to work for us, steal it, and then go somewhere else. And I think that kind of grounding in the beginning would be a powerful way to set the stage for your legal arguments.
Okay, before I address my comments specifically to you, Ms. Wu, I do want to make one suggestion to both of you and all of you who are watching this. One of the most important things you can do when arguing a motion is you stand up and you say, I'm Joe Jones. I represent the Smith Company. We are here on X. The reason that's important is judges have very big calendars. They're huge, and so we need to be focused on it. I remember once I had someone come up and they said they represented Ford or something, and I said, well, that's great. I got 10 Ford cases on my docket. Which one are you talking about? And, the other attorney said, yeah, I represent the plaintiff against Ford on this case. And I was like, oh, okay, now I know how to focus my thinking. I'm not saying you did anything wrong, because neither of you did, but that's just something to keep in mind. Now, Ms. Wu, I thought you showed an extraordinary command of the facts and an extraordinary command of the case law, and what you did, which was really, really, really important and will serve you really well in your law practice, is you were able to talk about the law in terms of the facts of this case and kind of put them together. Not kind of, you did. Why is that important? Because, first of all, it shows that you know your record. It shows that you know the law. But more important than that, it is really helpful to the judge. There's an employment law case out there. It's called Foley versus Interactive Data. I have probably read that case 50 times in my career. But you want to know something? If you ask me what it stands for, I'd be like, yeah, okay, I know it. Let me think about it. But if I have a lawyer get up in front of me and says, under Foley, okay, I know what that case is, these facts, and you tell me what the facts are, all of a sudden I'm tracing back to that case, I remember it, and I'm with you, and I want to listen to you. And you did that, very effectively, and, it's a pretty unique skill, and you should cultivate it.
I'm good.
Okay.
Your Honor? I believe with that, the court is prepared to rule. I'm going to take a moment of personal privilege since I have the mic. This class is named after my mom. My mom graduated from Bolt in 1974. She took me here when I was a baby. And my mother loved the law. She was such a nerd. When we were cleaning out the house, she had reams of paper of her notes and her books. I'm looking at my sister because she's probably eye-rolling of how much we had to take out. I don't know if she would have loved the trade secrets, but she would have loved the combination theory. She would have loved the, the standard on the pleading, the stuff that Judge Grillo probably would not want to talk about. She would have loved to just nerd out about. So in all seriousness, I just wanted to thank both of you for your preparation, for the hours that you put into this case, because it means a lot to my family. My brother, my sister, my father, my wife are here, along with some dear family friends of my brother's. And it just means a tremendous amount. So I know that this is just another class, another credit, all those things, but there's sometimes there's higher meaning in this stuff. So I just wanted to put that out. So thank you both. You really did a tremendous job. Hopefully this is the last time I get to say this. The court is prepared to rule. Given the facts, the argument, we are going to overrule the demur and rule in favor of whichever one, the Ocean View Analytics. And we have trophies for both of you. I think with that, court is adjourned.